Hi, good afternoon, everyone. This is Rajiv S. Khanna for Immigration.com, the law offices of Rajiv S. Khanna, PC. Today is October 11th, Thursday, October 11th, 2012. This is a conference call. It is not meant to create an attorney client relationship. You may want to keep your identity confidential because this call is being recorded. If you ask a question, make up a name. But if you want to give your real name, that's okay. But make sure you understand that this call is being recorded and it will be made publicly available. As I always do, first I will answer the questions that have already been posted on the forums. Then I will unmute the call selectively for those people who have follow-up questions. I think we should be done in about half an hour, 40 minutes. And then any follow-up questions we have from people who were not able to post on the forums or did not want to post on the forums, we'll open the questions for anything that's left over. On the forums, the first question is from Joe211. Joe has an N400, citizenship that was applied in Feb 2012, got fingerprinted 4 weeks later. Then he was supposed to be in line for an interview, but he's not been able to get anything from the government. Tried the ombudsman. I think what you should do, try contacting your congressman. Okay? I think the congressmen have a much better resolution rate in cases of naturalization than the ombudsman does. So if you don't know how to do that, just go to our website. I have a video posted on how you can contact your congressman. Okay, so do that. They can get you an answer fairly quickly. I suspect this could be because of security clearances and all. Next question is A. Agar 2003, who wants to know, look, I've got my H-1B. But I also have an F2 visa stamp. I'm in India. So this F2 is valid till Feb 2015. Okay. Then I've got the H1B approval for the current company I'm working for, but they don't have any assignment. Can I travel on F2 on, say, October 31st? You can. Yes. During travel, am I required to carry or mention the 797? You are not. Typically, you are not even asked about it. You just need whatever regular F2 paperwork is needed, which is I-20, visa stamping, etc. So you can double check with the school, DSO, if there's anything specific you should be carrying beyond that. Now, after 1 month of my travel in USA, if I want to change back to H1, can I do it without having to travel outside? Yes. Do I have to file for a change of status? Yes. How is that done? Well, change of status of an H1 is pretty much like filing a new H1 all over again. It's a little bit less fees, but other than that, it is just like filing a new H1. See, H1 amendments, H1 change of statuses, H1 extensions, new H1s, they're pretty much the same documentation. Okay. Number 3, I have the petition number without a copy of the actual petition. If I change employers while still in India and the new employer plans to file for a business visa or L1 visa, that's okay. Even if you don't have an I-797, you can just mention the name of the old employer who had the H1, and that should take care of it. I don't think you have to do anything more than that. They have an undisclosed policy of screwing my life. Okay, well, yeah, that is very unfair. But they're not giving you the I-797. That does not stop you from filing an L1 or a B1, B2. And you can let the consulate know if they question you that you don't have any access to the 797. Suppose I get the 797 approval and stamping done for the existing client. Then if I leave the current company without traveling to US, Can I transfer? Yes, you can. You can transfer actually without um, visa stamping. If you just get the 797 approval, or even the number, I guess we've done it with number if I remember correctly. So if you just get the 797 approval copy, you can actually transfer over even though you don't have any pay stubs for the current company. See, the transfer basically is to take you out of the H1 quota. Once you're out of the H1 quota, you are not in USA. You are not supposed to have pay stubs. That's fine. Okay. Will pay stubs be an issue for the H1B transfer? I already addressed that. Will I be required to get my visa stamped again? You should. That's what the consulates have been telling us. In a situation like this, when you're outside USA and you've got a visa stamp for one employer and you haven't yet traveled to USA, you should get it stamped again. That's what they tell us. If you are already in USA and you have the visa stamp and you changed employers, you would not have to go for another stamping. Okay. But if you are outside and without traveling to USA, you've changed your employers, they'll probably want you to apply for a new H1 visa. If I leave my current company, can my approval be cancelled? Yes. Will there be a problem in transferring? It shouldn't be. I'm assuming that H1B is valid for 3 years. I don't need to apply for fresh H1B. I don't think you'll be under the quota. I don't think that's a problem at all. Will there be difficulty in transferring? I don't think so. I don't think so. So if you leave without 1 month, without even beyond 1 month of the approval, I don't think that's a problem. So leaving early and transferring over to another company should not be a problem. Okay. Mitali Kashyap wants to know, my green card was initiated by my penultimate employer A in 2011. I-140 was cleared, PD is 2010. Later I joined company B, which started filing my green card. But then you left the company and the company B then revoked the labor. Now with company C, is there any problem if I apply for green card? No, no problem at all. If company A goes down, is that green card application in trouble? Well, I think that you will carry your priority date. Even if company A were to go down, you should be able to port your priority date, okay? Next question, I485_help. Hi, my husband is planning to travel to India for 2 months. Will be coming back on AP. He's between jobs since last 4 months and he's getting unemployment benefits. At port of entry, do they ask for employment letter? No, not usually. Is it safe to travel? I think he should at least get some kind of a hookup with an employer before traveling, because you never know what they are going to ask. The CBP can ask all kinds of questions. Even if you have a job offer which is same or similar to the green card job, that improves your chances of not having any problem in case you're questioned tremendously. The law in this area is gray. USCIS's stance is very simple. If we ask you, we'll give you 8 weeks or 10 weeks to produce an employment letter. That's fine. If we don't ask you, you can continue to stay. But CBP has never indicated how they are going to approach this situation where somebody is on AC-21 but between jobs. So I would rather that you don't take a chance. At least go with the possibility of a job offer in hand. Okay. Also, he has received an approved AP, but there's no information on fingerprinting requirements. You should contact the customer service and figure out what's going on. That's the smart thing to do. Ahmad Farooq wants to know, I have a J1 subject to the 212E. Can I stay a few months extra on a B2? Can I convert it without going back to home country or switching to my already issued B2 visa? Look, the only way you can do that is you would have to go outside USA and come back using your B2 visa. I don't see any other way of doing it, because one of the 212E restrictions is that you cannot change status within USA. Now, 212E, the 2-year rule, doesn't say that you cannot come back on a B visa. It says you cannot come back on an HL or green card. but you can come back on a B visa. Okay. However, to change status within USA is not possible when you have a 212E issue. Okay. Next question is SG22. He has a rather odd situation. 2797 approvals covering different periods. Look, here is what I can recommend to you. Under the law, you can enter USA 10 days before your next H1 kicks in. Okay, your second H1 kicks in, let's see, valid from Jan 2013 to December 2015. So that means around December 20th or 10 days before your 2013 Jan kick-in date, you can enter USA. But you can go for a visa stamping anytime. So you should be able to go for a visa stamping now. Use your January 2013 approval, get your H1 stamped, but enter USA 10 days before the start date. And that should take care of it. That's the way I would handle the situation. By the way, you can also ask these questions, whatever you asked me. I think that that's the best way to do it. You can send an email to the consulate also with these questions. No harm in asking them. And then in a couple of weeks when we do this conference call again, you can update me about what they tell you. Okay? The easiest solution is what I just gave you. Hari MP wants to know, my green card is approved, wife is not approved yet. Does USCIS process dependent green card based on the PD? Yes. Yes, they usually do. Very rarely they can approve it if they've already gotten a visa number for a beneficiary. But typically, let's say husband and wife applied, husband got approved, before wife could get approved for her green card, the priority date slipped back. If that happens, she has to wait until the PD becomes current again. But if you change jobs or something, that should not affect her at all. Okay. The only time following to join gets affected is if you change to naturalization. Sometimes what happens is the wife's green card stays pending for so long, you become ripe for naturalization. You apply for naturalization. The moment you get naturalized, she's no longer entitled to following to join. Then you have to apply for her I-130 separately, which is not the end of the world. But bear this in mind. Otherwise, you changing jobs is not a problem. Rakesh wants to know, master's degree in chemistry, working as a software consultant. Now he's got an RFE that says we need an evaluation from a college professor who must be authorized by his college to issue college level credits. That's a very common request. Nothing here that alarms me. What does alarm me is, if you have, first of all, I would like to know what your first degree is. Because your degree must have a relation to software development. Okay? But, in your case, since you are working for a pharmaceutical company, if what you do involves chemistry, for example, if you are developing a database for chemical compounds and knowledge of chemistry is important, then of course you are entitled to your H1, no problem at all. Normally what happens is, if somebody has an unrelated degree, I want to see 3 years of experience. So if you had a bachelor's degree in chemistry or a master's degree in chemistry and 3 years experience in IT field, you would have qualified even if you were not working for a pharmaceutical company. At least you had a good chance. Okay. So as far as the RFE is concerned, this is very normal. I'm not concerned about it. Travel to USA while green card in process. So there's a family who lives in Canada. Can they come to USA while their sister has applied for their green card? Yes. You can try. Well, no, let me rephrase that. The problem is, normally, for Canadians, the rules are a little more relaxed in terms of visiting. And if you already have a record of having come and gone, chances are they will let you come in. But technically, if you have filed for a green card or somebody has applied for your green card, they can refuse you entry on a temporary visa. Okay, so it's not guaranteed that you'll be able to enter, but I think you will be able to. So plan accordingly. Satnam wants to know what is the best way to apply for parents' green card. He's a or she is a U.S. citizen, and parents keep visiting. What is the best way to do this? Apply from India or apply from USA. The only thing I worry about when people apply from USA in these circumstances, I worry about government saying, well, you entered on a tourist visa, your parents entered on a tourist visa, but they had a preconceived intention of changing to green card, and that's not right. That's fraudulent. They've never done that, but I like to avoid that situation. So if your parents do enter, let them enter with no intention of changing to green card. If later on, after 60, 70, 80, 90 days, 3, 4 months, they change their mind, you can apply for a green card within USA. Okay. Now, as far as the your job change is concerned, your changing jobs should have no effect on the I-130 or 485. Okay, but you do have to show sufficient. If you have a job offer, you have to show job offer, tax returns, etc. for affidavit of support. So don't forget that. You will need to have that in play. As far as the date of birth is concerned, this is a very common problem, and we are dealing with it day in day out. And USCIS has become quite silly with their demands. If your dad has a non-availability certificate from the registrar, that combined with 2 affidavits from 2 people who were alive at the time he was born should be okay. Your mom will need a certificate of non-availability. Secondary proof like passport, etc. is not going to help, but yeah, of course, take them as well. Okay. Affidavits dated early 2012 are not a problem, but I do have a problem with the intent to immigrate. I just prefer, I think, why create an issue? Just get new affidavits, and the affidavits don't really have to be notarized. Okay. And what I would do is, if I were you, I would also state in a letter that you and your parents are willing to go through DNA testing if the government has any issue about relationship. Okay. But your birth certificate is probably there, right? You haven't written that. If you have your birth certificate, see, there are 2 different issues involved. One issue, Satnam, is that what is their date of birth? Okay, so we've covered that, non-availability plus 2 affidavits. The second issue is their relationship with you, and that should be obvious from the birth certificate. If you also don't have a birth certificate, you will need to get a certificate of non-availability and then get 2 affidavits showing the relationship. And as part of showing the relationship, you can also volunteer to the government that, look, we can do DNA testing if you have any problem with it. Okay. Next question is Godwish007 wants to know work authorization after the end of OPT extension and before H1 approval. So your OPT expires in March before the April 1st deadline of filing H1 kicks in. So as far as I remember, you are out of luck. You will not be covered by cap gap. Okay. I'm pretty sure, but I haven't looked at this issue specifically. What you can do is do a Google on ICE, Immigration and Customs Enforcement, ICE space, I would say OPT space cap gap or OPT FAC. Okay, then if it doesn't show up under OPT FAC, do it under cap gap FAC. In the frequently asked questions put out by ICE, a lot of this information is already there. Check that out and contact me again in a couple of weeks, and we'll talk further if you have any other questions. Okay. I have heard that within 2 months of my OPT expiration, my employer can file for an H1. That is correct. Since my OPT is expiring before April 1st, will this make me ineligible to take advantage of cap gap? Yeah, I think you don't get cap gap. Can I work during this time? You cannot, because gap doesn't apply. Okay. As far as I know, but double check the fact. See, prove me wrong. I would like to know that I was incorrect and there's some other information out there. I'm just speaking off the top of my head. Like I said, I haven't specifically researched this issue. How soon can I apply for EAD renewal? You can apply for an EAD renewal, I believe 120 days, approximately 4 months ahead of time. Okay. You want to know when will my priority date become current? I really cannot tell you that. Dame wants to know, I'm in the 9th year of H1, EB3 I-485 is pending. New employer is planning to file for EB2. Is AC21 required? Yes. I have covered this issue several times. When converting from EB3 to EB2, what you want to do is discuss with your lawyers that your current job with the new employer must be sufficiently similar so that you're covered by AC21. Yet you must have an EB2 green card filing. So even if you don't file AC21, you must be able to defend the job with the new employer as being sufficiently similar if USCIS asks for it. So it's a good idea to discuss this with your lawyers. You should be eligible for AC21 and still don't file AC21. That's okay if you don't want to. But even if you are doing EB2, make sure your EB3 rights are protected if government starts questioning you. Cat October wants to know, I came here on a B2 visa last April. Now I-94 expires in October. I've applied for F1. First of all, there is a regulation on the books, as far as I remember, that says you cannot convert from B2 to F1 unless while entering at the airport you told CBP you intend to convert. Now USCIS has been inconsistent about dredging up this regulation, but if they do dredge it up, they will create a problem for you. They will not permit you to do a B2 to F1 conversion. Okay. You are not considered to be illegal or out of status as long as your application for change of status is pending, even if your I-94 expires. Okay. Will my B2 visa still be valid if the F1 is denied? Can I come back? Well, if you are not out of status, you can, and it doesn't look like you are going to be out of status. Okay. So you should be able to use the B2 visa, but whether or not CBP, Customs and Border Protection, will let you back in when you come next time, that's another issue. That's really a matter of their discretion. Okay. Next question is from B. Dinga, adoption. They adopted their nephew before the age of 16. He's here. He's done 2 years of legal and physical custody. So the question is, does he have to apply for a green card or can he go directly for citizenship? I don't know the answer to this question. I want to say that you should be able to file N600, Certificate of Naturalization, directly. Let's take out the practical way. The best practical way is to go ahead and contact USCIS customer service. Get them to give you your answers. Do we have to apply for a green card? Can I do N600? Whatever answer they give you, confirm it through your congressman's office. And again, I have a video under the audio video content for how to contact your congressman. If you don't know how to do it, go ahead and review that, and then you'll be able to contact the congressman's office. Okay. As an attorney, would you take this case? There isn't really anything for me to take at this point of time. If something goes wrong or gets complicated, contact us. Sure, we'll be happy to assist you. But at this stage, there isn't much for us to do. Okay. Next question is Super Kings. their company has just moved all their green card applications to us, but he is stuck with his old lawyer and he doesn't like that they're not responding to his request. So his question is, hi Rajiv, do you take up a green card case from I-140 onwards? Sure, we do. And if your company is already our client, you just tell your company to set up a call between you and me, and we can go over what's going on. You are welcome to send me an email. You would have typically in our office, depending upon the size of the company, one or two permanent case managers in our office would have been assigned to your company. Check with any of your colleagues who your case manager is. Just tell them to set up a call with me. Or you are welcome to email me to help@immigration.com, HELP, help@immigration.com. You can also pick up the phone and call. Just leave a message. You can also send a message through the contact us form. So you don't need to go through this is a conference call for non-clients. Clients have, of course, access to me all the time. So we'll be able to help you depending upon, I may advise you not to take us because it could be cheaper for you to stick with the current attorney. But, as far as taking the case is concerned, that's not a problem. And it looks like you do qualify for EB2, right? I think it should work, but again, I haven't seen the paperwork. Does the applicant need to sign certified 9089? I think they do. I want to say they do. I don't deal with the details. I'm the strategy guy, so the details are handled by other people in the office. I do the reviews and the documentation and how the case should be presented. I don't remember, but I'm quite certain that you have to sign the 9089 when you file the I-140. Okay. PY, P. Yanamandra wants to know. This is kind of an interesting case. This is what I understood, PY. Your I-140 and 485 were filed using a substitute labor cert just before substitutions were stopped. But they mistakenly marked it in EB3 instead of in EB2. Now you're trying to get it amended. I would say you should contact your congressman and see what they can do for you. Okay? Because you want to find out which I-140 they are using, what's going on. I think the congressman's office may be the best way to go. Because you want to find out, under your application, how many I-140s are filed. See what the congressman can do for you. Okay. Can your previous employer file another labor petition and file my I-140 again under EB2? Sure. Absolutely. I don't see why not. If you want to start a green card all over again, you can. B. Sundar wants to know about H-1B stamping. He wants to know, I understand there's a change in the visa stamping process. I haven't really paid much attention to it. I know that they've changed it in India, not everywhere else. In India, they have interposed another private contractor, so you basically make your appointments and send all your documents to the private contractor. The procedure shouldn't be that complicated. It's available online. I don't remember off the top of my head what you're supposed to do. Are you required to go to your mother country for H1 visa stamping? No. If you go to Germany, you should be able to apply from Germany. Of course, as a matter of courtesy and certainty, you can always send an email to the German consulate, US consulate in Germany, and say, will you take my H1 application? I have never known any consulate to turn away a third country national, TCN they are called, TCN. So even though you are a TCN, a third country national, they should be able to take your application. And since you are a direct employee of a good company, reputed company, chances of visa stamping are pretty good. I also want you to consider going to Canada or Mexico for your visa stamping. Okay? Look into that. For a friend of yours, there's a question. How does the priority date for a green card advance? I had promised you guys that I'm going to draft a more detailed explanation. I haven't had a chance. They've given me a draft in my office of the paperwork explaining the process. I don't know when I'm going to get time for this. I've been very busy in a couple of things. Let me just give you an overview. Every country in the world has the same number of green card allotted to them. Okay? Whether Vatican City of 300 people or India of 1.3 billion people. Same number, 10,000 or 7,000, whatever that number is. Okay? So that's the first silly thing. Every country has the same number of green cards allotted. Department of State keeps track of the visa demand, which means how many green cards are being asked for. They get data from USCIS, from overseas consulates of how many visas are being asked for. According to that, they project statistically how many visas they can allot in any one particular quarter, 3 months. So they do three month to 3 month evaluation. They move the priority rate based upon their statistical projection. There is also some rule on what percentage of visas out of the total number available to a country they can allot in one trimester. Some of the loopholes are, for example, if you convert from B3 to EB3 to EB2, you are being counted twice for that calculation. Okay, so that can skew or twist the number of green cards being demanded. It can create a little bit of an artificial backup when there isn't. May not be a very large percentage, but every little bit counts. So once again, what are the rules? Fixed number of visas. Of course, higher visas can trickle down to lower numbers. EB1 can trickle down to EB2. There are certain rules on that. All visa numbers, the green cards, are based upon a statistical projection which State Department makes, and the visa allocation is done according to certain rules. Okay, so and those rules govern how many maximum they can issue each trimester. In a nutshell, that's the system. Okay, will the situation improve? I don't think so. Not unless Congress steps in or government steps in. It doesn't look like we are going to have too much improvement because the number of people is not going to decrease. Okay. Next question is B2 to E2. Well, first of all, when you enter USA on a tourist visa, converting to E2 can be taken to be a misrepresentation of your intention, your family's intention, when they entered USA using B2 visa. Because the idea is B2 is being given for a very short trip. You come here and you apply for an E2, they may not like it, but again, it depends upon the facts of each individual case. I cannot make a general rule for this. General rule, if any, is only this, that B2 means you are coming in for a short duration. If you convert to F1, H1, E2, it can get problematic. Can you get green card from E2? Not directly. A lot of people go through the investment green card EB5 route, which is the investor visa. Some people actually do a labor certification through a future employer. But there is no direct way like there is for L1A. You can directly get your green card, EB1 green card. You cannot do that for E2. Okay. I think I've covered all the questions that were posted. That took us about half hour. Now, before we go forward to new questions, anyone who has a follow-up question on what we have just discussed, press 5* on your phone. Anyone with a follow-up question, press 5*. No new questions, only follow-ups. For new questions, we'll open in about 5-10 minutes once we finish this. So I see 2 hands up so far. 5*. Okay, 2 questions, 3 questions. All right. Let's start with, in the order of the time you guys logged in. Area code 201, go ahead please. Area code 201. Yeah, 1 second, okay? Let me just, give me 1 second. Let me switch things around, okay? Can you hear me? Okay. Can you hear me now?
Yeah, I can hear.
Okay, excellent. Go ahead with your question, please.
Yeah, the question I had posted was the same with 2797 forms, which you obviously said is an interesting scenario. And in fact, that's what it sounds like, because not many people have, seen that scenario. Actually, yes, so you told me that, I can actually go for a current January to 2015 I-797 and then come 10 days earlier than it kicks off. But due to some circumstances, there's my wife is actually doing some studies and stuff, so she wants to come back really quickly as soon as she can come back, and I have to go back. So what I'm saying is, can we just while we're following what your advice is, actually at the time of the interview, tell the consular officer that hey, we have a continuity in the H1B stamping, so can you grant us from November itself? Or can it confuse the officer if he actually asks him?
No, I don't think it should confuse them, but I have some serious doubts about her ability to enter while you have not even entered.
Of course, sir, we will enter together. The only problem is because she has to enter, I could have still delayed my coming back to US.
Yeah,
like by December 20th or 21st, as you said. But she wants to come because she is doing some courses. If she loses attendance, then the whole 6 months she has worked hard would go down the drain.
Okay.
So that's the problem. So
yes,
I wanted to come back in December first week itself, or so it's a very difficult situation.
Hang on. Let me clear something up for you. I do not believe the consulate can stamp a visa for more than 3 years. Okay? So, the consulate can only stamp visa for 3 years, but it doesn't hurt to send them an email and ask them about this situation.
So another option I had was going for showing them the older 797, which is expiring in December 2012. And at the max, they will grant 1 month visa, which is obviously again a difficult situation. But at least we can enter the country with a 1 month visa, right?
You can, yes, you can. You can also show them both I-797s and let them do what they want to do. Okay.
So
obviously,
let them decide what they do. But for DS-160, I should use the most recent one, which is until 2015. The DS form allows you to fill only one receipt number.
See, what you should do is you should put down, if you want to use the old one, you should put down the old one. That's the way I would do it, which is the one good till only December or whatever.
Okay, sir. And you mentioned contact them through email. Actually, sir, the reason that the emergency came, actually, we are going to Australia for my brother, and actually I got the PR ship approved there, and I have to make the first entry there by November. Otherwise, they will, revoke my PR ship. So that's the concern. So I have to go there. But you saying I contacted them. I contacted the Sydney consulate through phone. The customer service guys. The different guys, they tell different things. Like they even seem.
Send them.
One said this, the other guy said this. When I called them.
Okay, I got it. Listen.
Calling there, sending an email, so that would be more authentic. People would be answering those.
Yes. I believe an email is likely to be more reliable.
Okay, I have to find out then. And I can go to Australia with, even though I'm not going to India or Mexico or Canada, but Australia is okay, as you answered, as you mentioned previously, that we can go to any country. It should not be a problem even if we are third country.
Well, in your case, wait, listen. Try to keep some breaks in there because otherwise I'll not be able to explain certain things to you. One very important thing to remember is if you are an immigrant to a third country, you are no longer a TCN. You are actually applying in the right place. So if you are a citizen of India and an immigrant of Australia or Canada, you can apply as a first country national in both countries, in India as well as Canada. So India as well as Australia, you are not a TCN. You have a right to apply there.
Okay, sir. That is fine. Because recently there was some concern. Somebody raised doubt in my mind that you have to have special permissions before you can go to any country like this.
No.
If they grant permission, then only you should apply. Some colleague of mine said you can't go to Canada also. You have to have special permission from the consulate before applying.
No, that's
Don't
incorrect.
need any special permission.
That's an incorrect information. Okay.
Okay. All right, sir.
Good luck to you.
I think I have the questions answered, but again, there's a dilemma of how to. So, final suggestion is use either one of them, but just go to the consulate and explain it. I think that's what I'm.
Before you go in, send in an email. Before you go in, send in an email with your questions. If you're filling out the DS form, fill out the old one because you want to come early.
Yeah.
When you go there, produce both forms. Let them do what they want to do.
Okay, sir. And once we enter the country, and even if they gave us the January onwards visa stamp and the receipt number is from the January onwards, I understand that I can come from December 21st. But if I come earlier and I show this 797 form to the US, at the port of the entry, if I show it,
you will not be able to enter. You will not be able to enter unless you have a visa stamp covering the date that you are entering on.
Okay, sir. Okay, and that it has to be tied to that receipt number. But two visa numbers, two receipt numbers can't be tied to the same visa. So
they can be.
Or
they can be, but the consulate cannot give you more than 3 years visa.
Okay, sir.
Okay.
So maybe notation can help. Maybe I can ask a consular officer to give a small notation at the appointment time that that.
No, now we are just guessing. Now we are just look. I don't want to indulge in guessing. I don't know what they will do. You can certainly ask them.
Sure.
I have told you what the law, by law, they cannot do certain things. Okay. Good luck to you, sir. I gotta move on.
Thank you, sir. Thank you very much. I appreciate it.
You're welcome. Bye bye. Okay, moving on. We have 3 more hands up. Area code 617. Go ahead, please.
Hi, thank you, Mr. Rajiv.
You're welcome.
Question number 18.
Yes, sir.
So you said this is a complicated issue, and you assumed that it was, or my I-140 or 485 have been filed after, actually not before, but after.
You see, if they have been filed after the deadline of substitution, they cannot be used. Obviously, if substitution was discontinued, I think it was in 2005 it was discontinued. Once it is discontinued, you cannot do any substitution. Okay, so
No, but how USCIS accepted my application?
They must have made an error. They make errors. They make errors all the time.
So how do I get this rectified? Because my original labor petition is 2006 June, and my attorney, she sent a 2003 October labor petition with my application, and they accepted it.
Okay, no, they have made a mistake. They have made a mistake, and as soon as they discover the mistake, they will throw out the I-485. And they will say that this I-485 was accepted in error.
I couldn't hear you there. Sorry.
They will say that I-485 was accepted in error. They will throw it out.
Oh, okay.
Okay.
But it's still under pending case.
It does not matter. USCIS makes errors. The moment they notice their error, they will throw out the I-485. No question about it.
Okay. So even before they throw out my application, because I don't want to lose the priority date or so on.
Which priority date are you talking about? Hang on. Which priority date are you talking about? 2006 or 2003?
Because 2003 is the one that...
You cannot get 2003. You're not entitled to it.
Oh, that's what. So if even if I try to send out 2006 application has expired too, because 2006 it lasted only until March of 2008.
But why did they not file a second 485 for you? Or they should have filed a second 485 with, well, let me rephrase that. First of all, they should have, did they file an I-140 for the second POM?
They didn't. Looks like they didn't. At least when I talked to my employer, he says we didn't. And when I talked to the USCIS, National Customer Service, they say they hinted at it, but they didn't.
No, this appears to be very messed up. and we are all making guesses here, you and I both, but let me tell you what the law is. The first I-140 was accepted in error, so the I-485 and the I-140 will be thrown out when the error is discovered. If the second POM that they did was not filed with an I-140 on time, that is gone as well. There's nothing you can do with that. So you have to start another green card, and the priority date will be 2012.
2012?
Yeah.
Okay.
If you do it this year,
Let's say,
if you do it next year, it will be 2013.
okay, if I file my application in the next few days or few months, can I port the 2003 priority date onto my new application?
You cannot port 2003, you're not entitled to it in any way.
Okay.
The moment they discover their problem, they will take it away.
Okay.
Second, you're not entitled to 2006 because the I-140 was never filed.
Yeah.
That means you're entitled to nothing. That means you have to start something. And I would say file another POM application as quickly as you can.
Okay. But how is it that my wife's EAD application, let's say my applications are in the
Let me stop you for a second. Do you remember 9/11 when the two towers were destroyed?
Yes.
One of the terrorists, guy by the name of Muhammad Atta, had applied for an extension of his tourist stay in USA.
Okay.
Even after he was found to be a terrorist and he was, everybody knew that this is a notorious terrorist, after his death, USCIS approved his tourist visa extension. How they do it, that's a mystery. Part of it is they have very large volume of cases, they do all sorts of things. So just because, don't try to find big reason and big logic in the fact that your wife's EAD has been approved. It means nothing. Okay?
But can she work on the EAD then?
Yeah, as long as she has an EAD. I personally would not want her to because I am very conservative. Ask somebody else who's more aggressive, they'll say, yeah, if they've given you the EAD, you can use it.
Okay.
All right?
All right. Thank you so much.
You're welcome. Good luck. Okay, we have 3 more actually. So let's go with area code 972. Go ahead, please. 972. Area code 972.
Thank you. Thank you for taking the call.
Yes, of course.
I went through your video blog on the AC21. It was very
Hang on 1 second. Is this a new question or is it a posted question?
a follow-up question.
Follow-up question. Go ahead. You went through my blog on AC21. Then?
Right. I had one question. Do I need to do AC21 to preserve my EBP priority?
You do not.
Okay. So it is up to the law firm to decide whether they need to file it.
The only reason we like for you to do to at least be able to defend. You see, let me take a step back. What is going on here? You move from employer A to employer B ostensibly under the right of AC21, right?
Right.
So the question is, what gives you the right to transfer a job under AC21? It is not informing the government. Informing the government is not required. But what is required is that the two jobs are same or similar. So you want to make sure in a meeting with your lawyers, are these two jobs same or similar? Because that way if you get questioned about your AC21, you have a good answer. And at the same time, the second green card under EB2 can keep going.
Okay.
Understood?
Okay. Okay. That explains.
Good luck to you. Bye-bye. Okay, so the last, well, appears like somebody else raised their hand again. Okay, let me try to do as many as I can. Area code 732. Go ahead, please.
Hi, good afternoon, Rajiv. I joined your call a little bit late, so I'm not sure whether this question was covered or not. I had raised this question earlier. This is regarding traveling on advance parole without a job. And
Okay, hang on one second. I have answered that question, and I want to note this for everybody. It's not fair for you guys to not log in on time and then have me repeat my answer.
yeah, that's the reason
Okay.
I was the last one to raise the hand. I don't want to
Okay, no, because there are other people waiting as well. So in future, everybody please make sure you log in on time. And if you have not heard the answer, then wait until you heard the recording because your question has been answered. Bottom line is this, I'll repeat it for you this one time, but I won't do it again for anybody. The bottom line is this, I said that under the law, it is not required that you maintain a job all the way through for AC21. But what is required is, if the government questions you, where is your job, same or similar job, you must be able to produce either a job offer or the fact that you have a job that you are doing which is same or similar. When you enter from outside USA, what is CBP going to do? We don't know. They should not be asking you these questions, but if they want to, there's nothing in the law that stops them from asking. They can ask, where is your same or similar job? Why are you getting into USA? So at that point, it could become a problem. So my advice was, before you enter USA on advance parole, hoping for AC21, when you are in between jobs, it is better to have a job offer of same or similar job in hand.
Okay.
Okay?
Okay. Thank you, sir.
You're welcome. Good luck, sir.
Thank you.
Okay, it looks like somebody has raised their hand again. I think I've answered these questions. I'll only be able to spend a couple of seconds with you. Go ahead, area code 201.
Sir, sorry about that. There's an important thing which is left out. This is that same 2797 form question. This is Samir here. Sir, if provided they give me just 1 month visa and I use the older one and only 1 month, when I enter here, would they, on the I-94 which they give me, that would also be for 1 month only?
Yes.
The date on the I-94 which the
yes.
port of entry they put.
Yes.
Put the date.
Yes. The answer to... Listen to me. Listen, Samir.
After 1 month I would have to again
Samir,
leave the country?
what you would have to do, in my opinion, is probably apply for an extension.
Extension is already there.
I know you have an extension. I know you have an
extension.
Yaar, ek to na, you don't give a gap anywhere in the conversation. So I can't really say anything. I told you to please take a breath. Give me a little gap so I can get my word in edgewise. Bottom line is, when you have two I-94 approvals, one of a shorter duration, one of a longer duration, in my opinion, there's a whole history behind this. We can go into a very lengthy discussion. In my opinion, the safest thing is to apply for an extension again. Okay? That is the safest thing. Now, 10 lawyers will give you 10 different opinions, and they are all right and they are all wrong. We don't know. If you get something in writing from the government, great. If you don't, you can also do this when you come in on the shorter duration I-94. You can ask your lawyers or your employer to get in touch with the congressman's office and get an answer from the government.
Yeah, but at the port of the entry, the date which is handwrite on the I-94, that could be depending upon the small 1 month visa only. If I use a smaller duration.
I think that's what they will do. You can ask them for, even they can't give you more than 3 years. They can't give you 3 years and 1 day. Okay? So, you can ask them, look, I have another I-797 approval. Can you give me 3 years? So, in other words, can you give me 1 month plus 2 years and 11 months more? You can try, but I'm not sure what they will do.
Okay. But at the time of departing, I have two I-94s now, obviously, the latest one which came with the new latest extension. So I would have to give away both the I-94.
I don't know the answer to that question. You'll have to check with the CBP. At least one you will have to surrender. I don't know if you have to surrender both. Look, I have to take other calls, Samir. There's a lot of people waiting.
Sure, man. Sure,
Okay.
sir.
Good luck to
Thank
you.
you, sir.
All right, bye-bye.
Thank you.
Okay, area code 905 has raised their hand. Go ahead, please. 905.
Hi, I have a question, a follow-up question regarding to the family sponsorship for green card.
Yes.
I understand for Canadian citizens the rules are more relaxed, but how if one of the relatives is on a B1, B2, can they travel on the visit visa while the application is in process?
That's what I just said. Technically, they can be stopped from entering USA at any point of time. If you have a B1, B2 or an F1, any of the visas that require you to have non-immigrant intent, entry on those visas can be denied and a renewal of those visas can be denied. However, if you have a good record of having come and gone before, the fact that a green card was filed still would not be a major, well, it depends. If CBP wants to make it a big issue, they can. If they don't want to make it a big issue, they can let it slide. What I would advise is don't take it for guaranteed that you'll be able to enter or not enter. Either is possible.
Okay. And then for parent sponsorship, if they're already in the United States, does the I-130 and 485 get filed concurrently, or are they done one after the other?
No, that's done concurrently. If they are parents of a US citizen, it's done concurrently.
But if they're outside USA, then they're done one after the
Yeah,
other.
485 cannot be filed if you are outside US.
Oh, I see. Okay. So you just file for 130.
You file I-130, then when the I-130 gets approved, the file goes to the National Visa Center in New Hampshire. From there, the file gets sent to the consulate where they are, and they get interviewed there.
I see. And at that point, you file for 485?
No. The consular processing is an alternative to 485 for those people who are outside USA.
I get it. Okay.
485 is the alternative to consular processing for those people who are inside USA.
Oh, I
If you are inside USA, you can always choose to go for consular processing instead of 485.
Okay.
Okay?
All right.
Good luck to you, ma'am. Okay, any questions at all, guys? 5-star. Press 5-star. Any questions of any kind? 1, 2, 3, 4. Any questions of any kind? 1, 2, 3, 4, 5, 6, 7. No problem. I will answer everybody's questions. Whoever is on the phone, I will finish their questions before I hang up. Area code 215. Go ahead, please.
Yes, Rajiv, good afternoon. This is Shiv Sharma.
Ji Shivji.
I am a U.S. citizen and my daughter visits me every year. And now we want our daughter, she's on visitor visa, because my daughter and her husband, our family. While they are in U.S., can we file 130 and 485 together?
I don't believe so. Married child, let me give you the times. Because see, in order for 485 to be filed, Shiv, their priority date must be current. That means a green card must be immediately available to them. But it is not available for adult married children of US citizens. Let me tell you what the priority date is. Give me 1 second. They will come
Well,
on.
I looked at the priority date, yes, at the visa bulletin.
Right.
But can this, when I file a 130 petition for her and her family, can they stay in U.S.? or
They
not?
cannot. They cannot. No.
They cannot.
No, sir.
So again, this is a kind of follow-up question. As they already have B2 visa, so if when their petition is pending or filing is I file 130, so can they visit us without any question?
They can be stopped at the airport anytime. Because if you have a green
They have
card,
their record has been good in coming and going back.
well, you know, Shiv, the problem here is this is now completely at the discretion of the CBP officer. If he decides he doesn't want to let them in, he can tell them, I'm not letting you in, take the next flight back.
I understand. Thank you.
You're welcome. Okay, let's go on to the next question. And I'm getting people. Um, I'm calling upon you guys based upon the time you logged into the conference. Area code 617. Go ahead, please.
Hi, this is in regards to question number 18 again.
Mm-hmm.
So, is there any possibility that I can apply for my green card EB1 when I'm applying it in 2013?
I don't know your resume.
I am.
No. Now is not the time to discuss it, Mr. Yanamandra, because we don't have enough time, and it's not fair for me to just spend so much time on one person. You can send me your resume to help@immigration.com with just one request to assess it for an EB1. I'll take a look at it.
Thank you so much.
Good luck. Okay. Now there is one person who logged in at 12:28 p.m. Eastern Time, but they have no phone number. So you may be calling with Skype or one of those services. Go ahead.
Hi, Rajiv.
Yeah.
Can you hear me?
I can hear you. Yes.
Yeah, I was on this Skype and my phone crashed. First of all, thanks for doing this and to ask my question.
Sure.
I have been on H1 for over 6 years.
Okay.
My previous company did file for my labor, it got approved. They filed for my 140, it got approved.
Okay.
So I switched to the second company
Okay.
and they got a 3-year H1 based on, actually 1 year, sorry, 1 year H1 based
Sure.
on the previous 140.
Got it.
The only question
Hang
have
on one
is
second.
now,
Hang on.
previous
Hang on. They should have gotten 3 years.
Yeah, and I'm checking with them. They said within 6 months we'll have to apply again. So
Okay,
we'll
okay.
do all the I'm
Okay.
guessing they missed the paper or something. They'll do the proper work to get the
Okay.
visa.
Okay, no problem.
That's a separate conversation. No questions there. I'm working with them. My only question is, assuming they file for this 3-year visa, they get the 3-year visa based on the old 140. My only question is, after I get my H1 approved, if my previous company cancels my 140, does that approved H1 stay valid or does it get invalid?
I have looked at the law. In my opinion, if USCIS wants to take that H1 away, they can. But I've been doing this for a few decades now. I have never seen them go back and take away an H1 that was approved. Frankly, I think there's some very strong legal argument against them trying to take away the H1. So, to answer your question, as a practical matter,
Right. No finish with that.
yeah, I don't think they're going to take it away. No.
Okay. And my last question is, before my company files for this 3-year extension again, if it is cancelled before, then I have no choice.
Then we have a problem. Yes, then we have a problem, definitely.
Got it.
Okay.
Thank you very much for your time.
You're welcome, sir. Good luck. Okay. We have 3 more questions only. 3 more questions only. Good. Making good time here. Area code 321. Go ahead, please.
Hello, Rajiv. Thank you for taking my call. I have a question for you. I've been a permanent resident for 4.5 years,
Okay.
but I only started really maintaining my residency about 7 months ago. I've been going back and forth a lot before that.
Okay.
And my question is, I've been sent to questioning about 7 months ago when I entered. They went through a lot of questions with me, and they were doubting my sincerity and everything. But fortunately for me, it stayed that way. Nothing else happened. But ever since then, when I come in, they keep on sending me to the room. I guess they just check my passport, they stamp it, and they let me in. They don't ask me any more questions. But every time I come in afterwards, they just send me to the room. I was wondering if there's such thing as some kind of entry and exit monitoring for a certain period of time, and when is it going to be over? I mean, every time I come in, I have to get sent to the room, and it's very frustrating and makes me very nervous. So,
The simple answer
and
is.
how long?
The simple answer is, as far as I know, there is no. If you were on some kind of a lookout list, such as based upon terrorist activity, okay, somebody suspected you of being a terrorist and they put you on the lookout list, we can take that name out. There is a procedure for it. But a lookout list based upon a suspicion that you've abandoned your green card does not go away, in my opinion, until you actually get naturalized. So the fact that they keep putting you in secondary inspection, taking you away, there is no real good remedy against that. And I don't want to push it. I could have told you, go to your congressman's office and see what they can do. But I don't want you to push it, because remember, if there is a discontinuity in the green card, they can come after your green card at any time, even though you have established permanent residence later on. Okay? The only safe solution to this is eventually to get naturalized. So whenever you qualify, please get naturalized and make sure that that gets taken care of. I have no easy solution.
Sorry. So whenever, there is such thing as monitoring. Like I get the feeling that every time I come in, they have something popping up on their screen that I need to be sent to the room. I don't think it's like the judgment of the certain clerk that's looking at me.
Right.
I get the feeling that they have something telling them that I need to be sent to the room. Is that how it works, really?
It probably is like that. But what they would have done is they would have made an entry on your database record, so that when your green card is scanned through and entered through, it pops up and it says, this person needs to be examined because they have a history of having lived in USA a lot less than we would like them to.
Yes, and I wanted to ask you, I've heard about that global entry thing, and I really wish to do that, but I also know that in order to be eligible, I need to go through an interview, and I was wondering if that would be a good idea for me.
I do not know the answer to that question. I have never had reason to examine a green card holder's entry based upon the global entry program. So I really don't know the answer to that question. If you want, you can, for this purpose, you can go through a congressman's office, or you can get a lawyer to specifically research this issue for you.
Okay, and just one last question. I want to know is it okay for me to try to be naturalized, even though, when I reach my 5 years, is it okay for me to try to be naturalized?
No.
And be maintaining my residency for the entire time?
In my view, you should naturalize 5 years after you have lived here permanently.
I see.
Once you establish, because I don't want them to question your earlier residence and create a problem for you. Many times people go for naturalization, end up losing their green card.
And if God forbid anything happens and they question me or they have problems with me for any reason, is it true that they cannot send me back? They need to give me a court date before?
Yes. A green card, they will put you through immigration court normally, yes.
I understand. And, because I have some history, just the last question, I promise. I have some history with it because they've been questioning my sincerity in the past, and I'm really afraid that one day, because I have somebody, it's like a long story, but I'm afraid that something might come up, and if God forbid I ever lose my residency, I'm actually right now, I'm actually engaged to an American man, and I'm also pregnant with this child and everything. So I was wondering if it would be okay for me to apply again if God forbid anything happens to me, or if that would be it for me.
No. If a green card is taken away just for the reason of abandonment, it can always be reapplied, no problem at all.
It might be for different reason though, not just abandonment.
Well, if it is for any other reason, then it depends upon the reason. For some reasons, you can apply for green card again and get a waiver for the reason of disqualification. For some things, there is no waiver.
The reason might be fraudulent.
Fraud is not by itself a ground that cannot be waived. There are certain things called aggravated felonies. It all depends. It's a very difficult question for me to answer without knowing all the facts. But normally, even if it is a disqualification of a rather minor kind, it can be waived if you are married to a U.S. citizen.
So is it okay for me to send you the actual the details on help?
No, what I would want you to do is get yourself, where are you? Don't tell me where you are. Wherever you are, get yourself a local lawyer. Okay? And because you might need to go for an interview or something and you want to take them with you. We don't travel, even though we represent people from all over the world and every major city in this country. Most of these cases don't require us to actually go anywhere. Okay? So in your case, it's a little unusual because if there is a green card interview of some kind if you end up losing it, or if there is any court case, they will do everything locally. You should go to a local lawyer who practices in deportation area.
I understand. Thank you so much. I really, really appreciate your help. Thank you.
You're welcome.
Good day.
Good luck. Okay. Now we have 3 more questions left. Area code. Oh, what happened? Give me 1 second, please. I'm trying to. Okay. Area code 201. Go ahead, please.
Hello, sir. Good
Hello.
morning. Small question about the Tri-Valley case.
Sure.
I was on H-1B and then got into Tri-Valley. But when this fiasco happened, I got back IL to H1 since I already had a previous H1. I was not subject to cap.
Okay.
But the H1 which I got after Tri-Valley thing was without I-94.
Okay.
So since I already had a valid visa, I got out of the country and re-entered and got a new I-94 which is valid for another 3 years. So I plan to go for stamping. So will that be seen as I was out of status for a brief time?
Look, here's the problem. There is a law on the books which says if you have been out of status for even 1 day, all visas on your passport are automatically cancelled. Okay? Therefore, traveling with a visa that has been automatically cancelled could be considered to be unlawful. It could be considered to be out of status. Okay? But this law is so weird, it is so difficult to implement. Government has not really been pressing on it much. Okay? So I believe if you are able to get your H1 visa stamping done, as you know, H1 visas are difficult to get anyway. If you are able to get your H1 visa stamp done, you should not have any problem with your past issues. Now, when you fill out the DS-160, you should mention the time that you were between the TVU incident and your I-94 approval and your visit outside USA. That time you should mention as out of status.
Oh, okay. But since you said that, if I were to be in out of status, my previous visas will automatically get cancelled, right?
But this law, I also said this law is known to such few people and implemented very poorly. I don't think it's going to become an issue.
Okay. Because I assumed that, I went out of the country and at the port of entry, there was no issue at all. He looked
Sure.
at my previous,
Yeah, but that's the problem with this law.
my new H1B, which was valid for 3 years.
That is the problem.
Yeah,
That is
94 for 3 years.
that is the problem with this law. There's no way to implement it. Because what has happened is an invisible cancellation. Who knows what was cancelled? Okay?
Okay.
Good luck to you.
All right, great. Thank you, sir.
You're welcome. Okay, 2 more questions, and then we are done. Area code 314.
Hi, Rajiv. Thank you for taking my question.
Sure.
I'm in H4 for 4 years, and I have applied for my H1 this year.
Okay.
Will my H visa 6-year period count from the date I started my H4 or from the day I'm going to start my H1?
H4 is no longer counted in H1. So you have 6 years of H1.
So my 6 years will count only from the date I start my H1.
That is correct. H4 is not counted.
Okay. Thank you, Rajiv.
You're welcome. Good luck. Okay, folks, I'm answering the last question of the day. This appears to be a call from outside USA. Too many numbers. Hello? Can you hear me? Calling from overseas?
Hello.
Yes, sir. Go ahead.
Yes, I can hear you. Mr. Rajiv, I'm the one who posted the question number 21 on your post. My question was regarding transfer from B2 to E2.
Yes, and I told you. Right. Go ahead.
Yes. You said that it is a difficult thing, but it is not impossible to get it done.
No, it's
work and everything.
It's inadvisable. Why? Because the government can take the position that you entered saying we are going to go in for a short time and now you're trying to convert to an E2, they don't like it. Okay? So B2 to any long-term visa conversion should be very carefully considered. My advice to you would be, decide if you want to do an E2. If you want to do an E2, get yourself a lawyer, let them decide whether they want to do B2 to E2 conversion or just send your family back to their home country and get an E2 and come back.
Okay.
Okay?
Okay.
So that's the way I would.
One more question I would like to ask in that one, that if I am getting an H1B,
Sure.
right, for myself,
Right.
and I go there on my H1, then my family is B2, can be converted to H4, or they would have to come back and then they can get the H4 from
when you get your H1, discuss it with your lawyer. These are all issues of very specific facts. I would say roughly, again, don't take my advice to be correct, but my quick judgment would be, it should be okay for them to convert to H4, because when they entered on B2, they didn't have an intention to convert to H4. You didn't even have an H1 at that point of time. So I can say that at that point maybe it's okay to convert to H4. But please discuss it with your lawyers who do the H1 when the time comes to convert them to H4.
Okay.
Okay?
Okay. One more related question, that their B2 will be expiring in say that at the end of November. So is it advisable to apply for the extension?
I don't like B2 extensions. I have a reason for it. They don't like us to take extensions unnecessarily. If you have a good enough reason, do it. If not, don't do it. Let them come back.
Okay.
All right?
Okay, thank you very much.
You're welcome. Good luck, sir.
Thank you.
Well, good talking with all of you guys. Thank you for being here, and I'll see you in a couple of weeks.